Okay, good afternoon. My name is Ronaldo Hilton. I'm the chairperson designee for the New York City Loft Board. Welcome to our October 19th, 2017 public meeting. We first turn to vote on September 21st minutes. Are there any corrections or comments on the minutes of last time? 21st, September 21st. Keep in mind we have 2 minutes, 21st and the 28th. So is there a motion then to accept the September 21st minutes?
Motion.
Mr. Roche. Second. Mr. Carver.
Mr. Carver?
Yes.
Mr. Barrett?
Yes.
Mr. Bush?
Yes.
Mr. Delaney?
Yes.
Mr. Jackson?
Abstain.
Chairperson Hilton?
Yes.
5 in favor, 1 abstaining.
So we turn to our attention to the September 28th minutes. I myself have a request for one correction, and that is in the opening paragraph. It says Chairperson Hilton stated that this meeting is primarily going to involve discussing lawful changes to the Loft Board rules. If I did say that, I just meant changes to the Loft Board rules. I think Loft Board changes is kind of that would make illegal, unlawful changes to the Loft Board. So it's just changes to the Loft Board rules. Is there anyone else with any corrections? Yes. Mr.
Yeah, it says that I called the rules creepy, but I said creaky.
What page is that? Sorry.
Towards the end somewhere. I don't think the rules are creepy at all.
Please, I've got a selection of words. Okay, we'll make those changes.
Okay, thanks.
Anyone else? Is with those changes and the motion to accept? Yes. Mr. Carver. Second. Any second? Mr. Barlow.
Mr. Carver?
Yes.
Mr. Barrett?
Yes.
Mr. Bush?
Yes.
Mr. Delaney?
Yes.
Mr. Jackson?
Abstain.
Chairperson Hilton?
Yes.
5 in favor, 1 abstaining.
Okay, before I turn to the Executive Director's report, I just want to make an announcement that Ms. Shelton has resigned from the board, and that's effective immediately. So that's one additional vacancy that's on us. But I just want officially to say to her that we want to thank her for years of service in the city. Do you remember how long? 10 years. She served 10 years to this board, and we want to thank her for that. All right, we'll turn to Ms. Boston, who will give us her report.
So, in terms of changes to the loft law, I wanted to inform the board that we are continuing in close contact with the Mayor's Office of Legislative Affairs and discussing the proposed changes to the loft law. So that is still very much alive, and they are working on it. In terms of the failure to file the monthly reports, for the May 2017 violations and fines, we mailed out 28 administrative determinations. 4 of the owners paid the fines. 1 called about appealing. We are still within the 45-day appeal period, which ends on 10/23. In terms of registration renewals, we have 46 buildings that still have not registered. The notices have gone out. Owners will have until November 23rd to respond. The unofficial total revenue for September was $28,593.50. In terms of rule drafting, we are almost done. I would say we are 98% done with our first pass. And we'll give you the material you haven't seen once we do one more pass amongst ourselves before we release it to all of you, and we hope that will be very soon. In terms of litigation, we were named in 2 suits this month. One was actually a housing court petition, Crane versus Dorian Realty. The tenant wants the owner to remediate mold. The second was a hybrid petition, Kent Avenue Holdings 1 LLC versus New York City Loft Board. This is a determination that the board made where we denied a code compliance deadline extension. There was a prior net lessee who then turned the building back to the owner, who then turned it over to another net lessee, and the second net lessee was claiming that they were a new owner. In fact, it's the son-in-law of the owner, so we found that there was no transfer of title and that they were not new owners. So that is pending. We were supposed to have a presentation for the mapping project, but unfortunately, the mapping person got called away to do something on an emergency basis.
He was called away to work on some Puerto Rico hurricane disaster project. So we apologize for that. It was a very last minute thing that, as you know, the Department of Buildings has quite a presence in Puerto Rico. And so we'll put this back on for next month.
And that's it.
Thank you, Mr. Fitz.
Just a couple of questions. The 46 buildings that haven't renewed their registrations, they have until November 23rd to respond.
To respond to the notices, so we sent them a notice saying you haven't renewed, you haven't renewed.
So some percentage will
Hey,
fail, but
Yes.
when will the failure of owner to register cases start coming to the board?
in the ideal world, hopefully we'll get them to you maybe November 30th, because we do have a meeting scheduled for that day. We were going to do rules, but we couldn't theoretically throw the FOs on that day. But that could be a pipe dream on my part, so don't hold me to it.
Soon after.
But as soon as possible. Yeah.
And you said that 28 administrative determinations have been mailed out with regard to...
This is the failure to file the monthly reports.
Right.
Yeah.
Now, I noticed we went through a lot of work getting the audio right today, or
Yes.
differently. And I know there was at least one board meeting in the past where the video that gets posted on YouTube did not work. Are we making an audio backup, or are we?
Yes.
We are.
It's right there on Ms. Rivera's desk.
I couldn't see it on
Yes.
my speak. Okay. Last question. I think this came up a couple of months ago, and I asked if we could get some updated stats on the number of buildings registered and their location.
That's the presentation
That's
today.
The mapping.
That was the presentation today.
But I can give you the information if you want. So,
Well, regardless of mapping presentation, I certainly understand that, if the city's able to lend people to the situation out in Puerto Rico, I'm very sympathetic. But it would be nice to just kind of get a file or a piece of paper with those figures on it.
so just tell me the exact figures you want and I will get that.
When we discussed this last, I suggested that you kind of work off the format that had been distributed every few months by the prior executive director.
Yeah, okay. Okay,
This would just be,
we'll have that for you next week.
it would be helpful to know how.
We will have it for you next week.
Okay.
The idea, what we were going to demonstrate to you today was all that information pretty much live on our site, and so we know the work is done. That's how it's done.
Right, and that, I look forward to seeing that.
Any other questions or comments regarding the director's report? There are two cases on the reconsideration calendar. The first case, number one, is 141 Spencer LLC. The address is 141 Spencer Street, Brooklyn, docket number R0352. Ms. Lovell, will you please present this case?
Thank you, Chairman. On February 24th, 2017, owner filed a reconsideration application seeking partial review of Loft Court Order Number 46114. In Order Number 4614, the Loft Court accepted the withdrawal of an application seeking protected occupant status made by the occupant in Unit Number 309. In the order, the Loft Court also fined owner $4,000 for the late filing of the sales record form and agreement alleging a prior sale rights involving the former tenant of Unit 309. According to the Loft Court Rule Section 1-07A2, there are only 4 circumstances under which the board may grant a reconsideration application. In its application, owner only alleged 2 of the 4 grounds. The first ground being that the Loft Court denied owner due process by imposing the fine without giving owner notice and an opportunity to be heard. The second ground was that the Loft Court erred in its determination because it was based upon a ground that the parties did not argue at the time the tenant sought to withdraw his application, and also because owner could not have anticipated that the Loft Court would have imposed the fine. In its reconsideration application, owner requested that the Loft Court reconsider the imposed $4,000 fine. In order to avoid potential denial of due process and in an abundance of caution, staff recommends that the Loft Court partially grant owner's reconsideration application only to the extent that Order Number 4614 imposed the fine. Staff also recommends that owner is granted the opportunity to submit additional relevant evidence as to why a fine should not be imposed pursuant to Section 2-11.1 of the rules.
Thanks, Ms. Lovell. Does any member of the board have any comments on this case? Is there a motion then to accept this case? Mr. Horowitz, is there a second? Mr. Shackman. Thank you. Mr. Ware?
Mr. LaFave?
Yes.
Mr. Bauer?
Yes.
Mr. Wu?
Yes.
Mr. Delaney?
Yes.
Mr. Shackman?
Yes.
Chairperson Hudson?
Yes.
6 in favor, 1 absent.
Thank you. The second case is being tabled, and so we will move on to the summary calendar. So there are 12 cases on the calendar. We are actually tabling numbers 10 on the calendar. That's TR 1305. The remaining cases are usually voted on as a block. However, the board members have agreed to vote on these cases individually. So I'm going to call them individually except for number 10. Case number 3, Michael Brett and Marty Levin at 53 Pearl Street in Brooklyn, docket number PO0035. Does anyone have any comments on this case?
I have some comments on this particular building, but since it comes up again in case number 12, I'll wait.
Okay, so is there a motion then to accept this? Mr. Carr, any second? Mr. Shackman. Then Mr. Barrett, please
Mr.
vote.
Bauer?
Yes.
Mr. Bauer?
No.
Mr. Roach?
Yes.
Mr. Delaney?
No.
Mr. Shackman?
Yes.
Chairperson Hudson?
Yes.
4 in favor, 2 against, 1 absent.
This is not passed. So let's go to case number 4, Samuel J. Chesterton at 33 Union Square West, Manhattan. Docket number PO0037. Does anyone have any comments concerning this case?
Mr. Jesselson also comes up twice to the summary calendar, and I will make my comments when we get to the second case.
Okay. So is there a motion to accept this case? It's Mr. Carr. Is there any second? Mr. Roach. So Mr. Rivera, could you please poll?
Mr. Carver?
Yes.
Mr. Bauer?
Yes.
Mr. Roach?
Yes.
Mr. Delaney?
No.
Mr. Chapter?
Yes.
Chairperson Henson?
Yes.
5 in favor, 1 against, 1 absent.
Thank you. We turn now to the fifth case, Ben Pomeroy, 473 through 493 Kent Avenue, Brooklyn, docket number PO0042. Does anyone have any comments on this case? No. Is there a motion to accept this case? Mr. Barros, is there a second? Mr. Shine. Mr. Shine. Could you please pull the board?
Mr. Carver?
Yes.
Mr. Roberts?
Yes.
Mr. Ruth?
Yes.
Mr. Delaney?
Yes.
Mr. Chapter?
Yes.
Chairperson Henson?
Yes.
6 in favor, 1 absent.
Case number 6. Sarita at 473 to 493 Kent Avenue, Brooklyn, docket number P00050. Does anyone have any comments on this case?
Yes, I'm going to vote no on this, even though it's on the summary calendar. This is yet again a case where the board allows an application to move through and deem settled without neither accepting nor rejecting the remaining terms of the stipulation. As I read this case, the tenant, in exchange for protected occupant status, which should be determined straight up or down, appears to have bargained for protected occupant status at 473, 493 Kent Avenue in exchange for agreeing not to participate in the Aaron Statement Conference. I am not supportive of the notion of tenants or owners being able to make that kind of bargain in terms of rights that are conferred either under the Loft law or under the Loft board's rules, so therefore I intend to.
Thank you. Is there any other comments in this case? So is there a motion then to accept this case? Mr. Carver? And second. Mr. Shackman?
Mr. Carver?
Yes.
Mr. Roberts?
Yes.
Mr. Bush?
Yes.
Mr. Delaney?
No.
Mr. Chapter?
Yes.
Chairperson Henson?
Yes.
5 in favor, 1 against, 1 absent.
Thank you. Case number 7, Samuel J. Jesselson at 33 Union Square West in Manhattan, docket number TA0223. Mr. Delaney has some comments. Yes, go ahead.
Yeah, this is a building that seems to have some issues. In this case, Mr. Jesselson, in good faith, finding no evidence of a 28612 sale, filed for both protected occupant status in case number 4 and a rent adjustment in case number 7. Lo and behold, the owner of the building was able to produce a 28612 sale of rights that had been executed apparently in May of 2006. And having this case go forward without fining the owner for failure to provide that 28612 sale wastes time and money on the part of tenants, tenants attorney, Loft board, both, and somehow we need to come up with a mechanism where these 28612 sales are produced in a timely fashion so that that time and money doesn't get us.
We'll take it. Is there any other comments on this case? So do we have then a motion to accept? Mr. Carver? Second. Mr. Shackman? Mr. Rivera, please call the board.
Mr. Carver?
Yes.
Mr. Roberts?
Yes.
Mr. Bush?
Yes.
Mr. Delaney?
No.
Mr. Chapter?
Yes.
Chairperson Henson? Chairperson?
Yes.
5 in favor, 1 against, 1 absent.
Thank you, Mr. Rivera. Apologize. Not paying attention. Case number 8, Ben Pomeroy, address 473 to 490 Kent Avenue, Brooklyn, docket number TA0227. Does anyone have any comments on this case? So do we have a motion to accept this case? Mr. Barnes, is there a second? Mr. Rowe? Mr. Berry?
Mr. Carver?
Yes.
Mr. Garber?
Yes.
Mr. Booth?
Yes.
Mr. Delaney?
Yes.
Mr. Chapman?
Yes.
Chairperson Hudson?
Yes.
6 in favor, 1 absent.
Thank you. Case number 8A, oddly numbered that way, but Nicole Crane at 1099 Flushing Avenue in Brooklyn, docket number TA0229. Does anyone have any comments on this case?
I'm going to vote against this case as I did when it was up last month, and the minutes very accurately reflect my objections on the decision.
Thank you. Does anyone else have any comments? So then we have a motion then to accept this case. Mr. Carver? Any second? Mr. Schachter?
Mr. Carver?
Yes.
Mr. Garber?
Yes.
Mr. Booth?
Yes.
Mr. Delaney?
No.
Mr. Chapman?
Yes.
Chairperson Hudson?
Yes.
5 in favor, 1 against, 1 absent.
Case number 9, John Durin at 67 Metropolitan Avenue in Brooklyn, docket number TR1289. Does anyone have any comments on this case? Okay, no comments. Do we have a motion to accept? Mr. Bowers, do we have a second? Mr. Carver? Mr.
Mr. Carver?
Yes.
Mr. Garber?
Yes.
Mr. Booth?
Yes.
Mr. Delaney?
Yes.
Mr. Chapman?
Yes.
Chairperson Hudson?
Yes.
5 in favor, 1 absent.
Thank you, Mr. Rivera.
6 in favor, 1 absent, sorry.
Number 10, as we said, is being tabled. We'll give case number 11, Marcus W. Mazza at 22 Catherine Street in Manhattan, docket number TR1308. Does anyone have any comments on this case? Is there a motion to accept this case? Mr. Carver? Mr. Bowers is second. Mr.
Mr. Carver?
Yes.
Mr. Garber? Mr. Booth?
Yes.
Mr. Delaney?
Yes.
Mr. Chapman?
Yes.
Chairperson Hudson?
Yes.
6 in favor, 1 absent.
Thank you, Mr. Rivera. Case number 12, Brent and Anwar T. Labette, 53 Fair Street, Brooklyn, TR 1313. Mr. Delaney has the floor. Comments?
Yes. My vote against this case and similarly the other case on the docket, number 3, these tenants filed an application and it turns out that the kind of a curious history, the owner registered 3 units, not including this unit, in August of 2012, and then in September of 2015 purchased the rights from this unit, allegedly it's a 28612 purchase from someone named Holly Baxter. At the same time, the owner goes out of the way in his papers to claim that the unit wasn't occupied residentially during the window period. So I'm confused as to how you can buy the rights of a tenant under 28612 that the unit wasn't residentially occupied during the window period. And again, my position is once an application is filed, whether it's filed by an application for coverage, whether it's filed by all the alleged residential occupants in the building, or one residential occupant who alleges there are however many additional residential units, that the party who filed the application should not be allowed to withdraw that application. The board, that the building either is or is not an interim multiple dwelling, units either were or were not used residentially during the window period. The This is not a voluntary program. And in this instance, there's just something that doesn't make sense about this application. And I think I will be urging the board, as it looks over its rules in the next few months, to consider looking at whether or not the board should be proactive and that the board has an affirmative responsibility to not only the parties in a given building, but also to New York City and the public to make up or down determinations on whether or not a building is a multiple dwelling, rather than have these kinds of situations.
Thank you, Mr. Day. Does anyone else have any comments on this? So we have a motion then to accept this case. Mr. Carver. So do we have a second? Mr. Shack. Mr. Rivera.
Mr. Carver?
Yes.
Mr. Bauer?
No.
Mr. Bruce?
Yes.
Mr. Delaney?
No.
Mr. Shacklet?
Yes.
Chairperson Hudson?
Yes.
4 in favor, 2 against, 1 absent.
This motion did not pass. Case number 1397 Wyckoff Avenue, tenants. This is 97 Wyckoff Avenue, Brooklyn, TR 1342. Does anyone have any comments on this? We then have a motion to accept this case. Mr. Carver. Second. Mr. Carver. Please pull the vote.
Mr. Carver?
Yes.
Mr. Bauer?
Yes.
Mr. Bruce?
Yes.
Mr. Delaney?
Yes.
Mr. Shacklet?
Yes.
Chairperson Hudson?
Yes.
6 in favor, 1 absent.
There are 4 cases on the master calendar. First case is number 14, Joel Saldino, Pablo Castro, Veronica Schwartz, Frank Hughes, Julian Asfor, Jean Castello, and 401 White tenants. The address is 401 White Avenue in Brooklyn. We have 2 documents. 2 document numbers, TR 1033 and TR 1158. Ms. Paulson will present this case.
This case involves the coverage of 6 units and 5 claims of protected occupancy in 2 structures located at 401 White Avenue and 62 South 6th Street. The units are referred to in the record as the Schwartz-Castro unit, the Asfor unit, the Lozani unit, which is also referred to as the Alonzo or Alfonso unit, and the Hughes-Costello unit, the Saladino unit, and the Ziegler unit. There was motion practice and 13 days of trial. The oath judge, Faye Lewis, recommended coverage for all of the units except the Schwartz-Castro unit. She also recommended that Dr. Asfor, Mr. Hughes, and Mr. Saladino be found to be protected occupants. In the order, the board, staff recommends that the board accept in part and reject in part Judge Lewis's recommendations. The first issue before the board is whether or not the board agrees that the structure is a horizontal multiple dwelling. Judge Lewis found, and staff recommends that it is. The building has common ownership. There is a common certificate of occupancy, common utility services, common piping for those utilities, and there is a load-bearing wall with a sliding fireproof door that connects the 2 structures. Next, the case involves 2 issues that the board has not decided before. One is how to determine if a unit is located in a basement, and what zoning resolution definition of court to use to determine if a unit has a qualified window. As to the zoning resolution issue, Judge Lewis did an extensive analysis of the issue and recommends, and staff agrees, that the definition to adopt is a unit is located in a basement if the floor elevation in the unit is lower than the curb level of the nearest street. Adopting this definition, that would mean that the Schwartz-Castro unit is located in a basement because the floor elevation in that unit is lower than the curb level of the nearest street, which for them is South 6th Street. However, the Hughes, Lozani, and Asfor units are not located in a basement because the floor elevations in those units are higher than the curb level on White Avenue, which is the nearest street to those units. As to the question of what zoning resolution definition to apply, of court to apply, staff proposes that the board accept Judge Lewis's analysis as to which definition of court contained in the zoning resolution to apply to coverage applications. Judge Lewis recommended that Judge Lewis states that there's no basis to go beyond the definition contained in the zoning resolution 1210, which is the definition section of the zoning resolution. The definition applicable to this case is one of the sections regarding outer court. An outer court is any open area other than a yard or portion thereof, which is unobstructed from its lowest level to the sky, and which, except for one opening upon a front lot line, is bounded by either building walls or building walls and one or more lot lines other than a front lot line. The Lozani and Hughes units would therefore have windows that border on an area that meets this definition. Any regulations regarding specific requirements is in a specific zoning district is an issue that pertains to legalization and not the issue of coverage. The Lozani and Hughes units meet all of the other criteria for coverage. Therefore, staff recommends that the board grant coverage for the Lozani and Hughes units. Other window issues, the parties stipulated that the Saladino and Ziegler units have windows that meet the eligibility criteria. We asked the board to agree with Judge Lewis's finding that the Hughes and Astor units have lot line windows that front on a legal rear yard according to the precedent in matter of Doris. As to the other eligibility requirements, staff recommends the board accept the report and recommendation of Judge Lewis and grant coverage for these units: the Astor unit, the Lozani unit, the Hughes Costello unit, the Saladino unit, and the Ziegler unit. On the question of protected occupancy, Dr. Astor has lived in his unit since prior to the effective date of the Loft law. He has never had a lease. He continues in possession of the unit. Staff recommends that the board grant Dr. Astor protected occupant status pursuant to 29 RCNY 209B1 and B2. As to Ms. Costello, she was the prime lessee of the Hughes Costello unit, but she did not reside in the unit on the effective date of the law and has had no association with the unit since 2011. Staff recommends that the board deny her protected occupancy claim. As to Mr. Saladino, Judge Lewis finds that he's the protected occupant of his unit pursuant to 29 RCNY 2-09, B1 and B2. However, since Mr. Saladino is the prime lessee of his unit, the analysis of his claim should fall under 29 RCNY 2-09 B4. The record establishes that he resided in the unit prior to the effective date of the law. He continues to use the unit as his primary residence. Therefore, staff recommends that the board find that he is a protected occupant pursuant to 29 RCNY 2-09 B4. As to Mr. Hughes, Judge Lewis found him to be a protected occupant pursuant to 29 RCNY 2-09 B1 and B2, stating that he is in possession of the unit because, even though he has not resided in the unit since 2012. Staff recommends that the board reject Mr. Hughes' claim. Mr. Hughes is not a residential occupant of the unit. Since 2012, he has leased the entire unit, including the bedroom he used to occupy, to others. Section 2-09B1 and 2-09B2 do not apply to him. The rule that applies to his situation is 29 RCNY 2-09B4, which covers both prime lessees, which he is not, and sublessors who are not prime lessees, which Mr. Hughes is. 29 RCNY 2-09B4 requires a sublessor who is not a prime lessee to use the unit as a primary residence in order to be a protected occupant. Mr. Hughes does not reside in the unit. Staff recommends that the board deny his protected occupancy claim. Thank you.
Thank you, Ms. Walton. Good work put into that. I understand, was there someone who wanted to take a motion on this?
Yes, Mr. Chair, if I may, although I think the
Loft Board staff did some outstanding work on this case. I personally, and I think maybe a few other board members have some questions that we would like some time to sort out in our own mind and doing our own research. And as such, I'm going to make a motion that we table this case until next month.
Is there someone else second? Mr. Carpenter.
We're out of order. Only the chair can table. The staff cannot
You're making a
make a
motion.
motion to table. So either you, and only the chair can table the motion. So either you will agree to table or not, but we can't do it as a board. Now, this is according to Robert's rules, and maybe I'm
Can you give me a second?
Mr. Chair, we could either all vote no in which case, and we'll have to say with that.
Right.
I appreciate that. So let me just ask the other members of the board so I can get a better understanding. How do you guys feel about, does anyone else have the same feeling that Mr. Roche before, that we need more time to do this?
I support that.
All right, so I'll grant the, thank you. So we're tabling case number 14. Mr. Berry, you don't have to do it.
Excuse me, Mr. Chair. In conjunction with that, I think it would be very helpful if some of the interplay of the various definitions that were discussed in our private meeting with regard to definitions of things where particularly there are differences of meaning in the multiple dwelling law versus the zoning resolution. If the staff could try to prepare a memo addressing that outside of the rather extensive discussion that the both judge in this case held in the context of the specifics of this case.
Sure.
Does that make sense?
Yes.
Okay.
Thanks, Mr. Delaney. The next case on the master calendar before us again, it's Andy Rishoy, Anna Holgren, Kelsey Knudsen, John Cannon, Janie Domingo, Emily Garcia, and Shigakazu Morita. I think I did better this month. Address is 58 Grand Street in Brooklyn, docket number TR1252. Mr. Bobby, could you please present this?
This application seeks Article 7C coverage for 5 units pursuant to MDL 2815 and protected occupant status. The building is made up of a 4-story structure and attached 1-story garage. Judge Spooner recommended coverage for the first, second, third, and fourth floors of the 4-story structure, but recommended denial of coverage of the garage unit because it lacks a window that satisfies the window requirement of MDL 2815. Owner argues that the building is an old law tenement, and as such, the building is not eligible for coverage. The I-cards demonstrate that as of December 1955, the building was converted to exclusively commercial use. The building's former status as an old law tenement does not preclude the building from coverage under the law. Staff recommends that the board grant coverage to the 4-story structure containing 4 IMB units. With respect to the protected occupant claims of people in the 4-story structure, Ms. Holmgren and Ms. Domingo, owner stipulated that should their units be found covered, they would be the protected occupants. As staff is recommending coverage for their units, staff also recommends that Ms. Holmgren and Ms. Domingo be found to be the protected occupants of their respective units. With respect to Mr. Cannon, based on the evidence in the record, staff recommends that Mr. Cannon be found to be the protected occupant of his unit pursuant to 209B4. Mr. Cannon is the prime lessee of the 3rd floor, and the 3rd floor is his primary residence. With respect to the garage unit has a retractable steel roll-down gate facing Grand Street. In 2003, an interior wall without windows was built behind the roll-down gate. In approximately February of 2009, a window was allegedly installed in the 2003 wall. In March of 2014, the 2003 wall was removed and an interior cinder block wall with windows was built. When the roll-down gate is down, neither the cinder block wall nor its windows are visible. The windows built in the interior wall do not satisfy the window requirement of MDO 28115. The roll-down gate defines the exterior boundary of the garage unit, and whether it is open or closed does not change the exterior boundary. The windows do not open onto a street, rather they open into the inside space of the garage unit. Tenants also claim that the skylights in the roof of the garage unit satisfy the window requirement of MDO 28115. However, the roof of the garage unit is not a lawful yard pursuant to the zoning resolution. Tenants also claim that the plexiglass cutouts in the roll-down gate satisfy the window requirement. However, tenants have failed to demonstrate that these plexiglass cutouts exist. Staff recommends that the board deny the coverage application for the garage unit because it lacks a window as required by MDO 28115.
Thank you, Mr. Bobbitt. Does anyone have any comments on this case? About this case? Okay, no comments then. Do we have a motion to accept this case? Mr. Carver, any second? Mr. Shattuck?
Mr. Carver,
Yes.
Mr. Bauer,
Same.
Mr. Bush,
Yes.
Mr. Delaney,
No.
Mr. Shachter,
Yes.
Chairperson Hilton.
Yes.
4 in favor, 1 against, 1 absent, and 1 abstain.
Thank you, Mr. Rivera. This case is again not passed. I'll speak louder. The next master calendar case is number 16, Celia Gong and Man Quen Gong. Address is 241 to 249 Center Street in Manhattan. Docket number TR 1283. Ms. Tuttle, can you please present this case?
On October 23rd, 2015, tenants occupying the third floor left and right units filed an application seeking Article C coverage and protected occupant status. In a stipulation dated November 18, 2016, the tenants agreed to waive their coverage and protected occupant claims and also withdraw the application with prejudice. According to Section 1-006J5 of the Loft Board's rules, when parties elect to settle their dispute and enter into a settlement agreement, the executive director may review the agreement. The Loft Board also has the authority to request, review, and reject the proposed agreement and remand the matter back to O for further investigation and adjudication. In its recent history, the Loft Board has rejected proposed settlements that result in a violation of law or public policy. For example, in matter of parish, Loft Board Order Number 4027, the Loft Board rejected a proposed settlement which permitted a tenant to withdraw his Article 7C claims in exchange for the tenant's continued residential occupancy in a space without a residential certificate of occupancy. The Loft Board also found that the proposed agreement in parish not only violated the law, but public policy. In the current stipulation before the Loft Board, tenants have agreed to withdraw their claims, but the agreement does not include a vacate date. According to the owner's attorney, the tenants still reside in the units and will not vacate until October 2018. Currently, the building does not have a residential certificate of occupancy. Staff recommends that the Loft Board reject the proposed stipulation and remand the application to O, as the stipulation violates the law and is against public policy.
Thank you, Ms. Tuttle. Does anyone have any comments about this case? Therefore, do we have a motion to accept this case? Mr. Roberts. Mr. Roche is second. Aye. Mr. Rivera.
Mr. Carver,
Yes.
Mr. Bauer,
Yes.
Mr. Roach,
Yes.
Mr. Delaney,
Yes.
Mr. Shachter,
Yes.
Chairperson Henson.
Yes.
6 in favor, 1 absent.
Thank you, Mr. Board. The last case on the master calendar is a removal case, and we are tabling this case because the Loft Board is insisting that the landlord withdraw an existing and permitted all-to-one application on the building which exists right now for residential purposes before we go forward. So we're tabling this case so that we can get some results from that.
I'm sorry,
Yes, there is you want me to clarify?
yeah, if you would.
Yeah, so there is currently an existing all-one application. They're asking, this building is going commercial. Claiming they're going commercial. However, there's an existing all-one application that exists right now for residential, is permitted also for residential purposes, right? So we're insisting that they withdraw that application before we allow it. Is that clear, Mr. Chairman?
Well, I ask you a question
No.
in public session. I'm sorry we didn't go into
Well,
that.
we'll have a chance next time.
Yeah.
Okay. Thank you. So that's the end of the cases. We now turn to item number 7 on the agenda, which is the Loft Board rulemaking. We'll pick up with Mr. Carver's comments on proposed Rule 217 and 218.
Before we
Yes.
chapter 2, can I just ask
Sure.
a question? At the last rule meeting that we held last month, in addition to starting to discuss chapter 2, we kind of finished our first pass at chapter 1. So my question is, can the staff create a, as it stands now, version of where we are with chapter 1 and distribute it to the board in the next few weeks?
I'd be more than happy to do that, but we're not quite done with chapter 1 because we still have an outstanding issue for 1-30, which was the settlement issue. So it's not quite finished, but I can certainly send you everything else.
Or if you could just, we did a lot of marking up
Yeah.
in a lot of places.
Yeah, I'll send it, sure.
So if you could send out everything and just highlight that
Sure,
1-30 is
Yes.
still an open issue. I think
Yes.
that'd be very helpful.
yes.
Awesome. Mr. Carver, I'm sorry.
Oh, okay. Subsection 17, we're on. So the concept of a responsible party, as defined in chapter 1, we're starting to see its use now, in the substantive section. But a responsible party is defined to include a lessee, and yet here, in this section, we're enabling a responsible party to, in essence, determine which occupants would have rights under this section. So I'm not sure you meant to use responsible party in this section. I think you mean to use owner or others claiming to be in the shoes of the owner, right? So your definition of responsible party is too broad, at least for this
For this
section.
purpose.
Yeah.
Yeah, I absolutely agree, and I think that we should say landlord or owner or management of the building. I don't like the term responsible party even when it first came up. But I totally agree with you.
Now, the other parties who are in the definition might have the rights of an owner, but that depends on the particular circumstances. Is it a contract between the owner and that party? Is it a court order? Is it the law? So I know the rule can actually say that those other entities have powers unless they actually do have the power, a contract or a court order.
or authorized representative of the owner?
Yeah, or cleaning hour through the owner, something to be thought over, I think.
I think that C, 216, 217C should come earlier.
Before we go, just on responsible party, you would include owner or other authorized individual?
I'm not sure I've used those words, even though that's the
In general, who would you be looking to include?
anyone who has the power of an owner.
So that could include an FLC.
I suppose that they,
We
yes,
accept
Operating.
registrations from NLCs now.
that operates the park in its entirety.
Yeah.
Yes. But I'm concerned about the owner often assigns its rights when it gets along, for instance. And the terms of that assignment, they may or may not have that power being assigned. So that's why I'm afraid to specify who, the owner specifically, has the owner's power. They would have to prove their power somehow. I don't think it's going to come up much, but it's just, I think it's just a flawed definition for purposes of this section.
Okay, so we'll discuss it internally,
Yeah,
we'll come
that's-
back with a proposal on it. I think that's a valid one.
I had some notes that just realized that it said owner or other holder of the owner's interest. That was language that I scribbled that might prove to be good, but we'll have to think it over.
Okay.
Oh, yes. Oh, well, not on B, but that was what I had B. 2.2.17B.
I'm sorry.
Yeah.
Can I just take a 5-minute break?
Oh, please.
I need to get some notes. I'm sorry.
Yeah, sure.
Please.
If the board would like clarification, I think it should certainly be when the board finds protected occupancy. I mean, normally, these things look back in time and people are coming in with hundreds of documents, and they were there during the window period, so it's really a distinction without a difference, except for Mr. Hughes actually sees the exception, and Ms. Mariner Smith. Those others that have moved out and admitted they moved out. So it seems to me that it's when the board is awarding them that status. So we can clarify it or we can leave it vague. I don't want to go too far because then you run the risk of being accused of being ultra vires because the law doesn't specifically say, the law says continues. And to me, I interpret that, as I said last time, as they were living there before and now they're living there still. They can stay.
Well, we
So,
should say that, then if that's the intent. No harm if that's what it's meant to do.
Go ahead.
it's up to the board. That's my belief. You know, looking at the legislative history of the 1992 amendment and the way that the language is worded in that section, that's my opinion. It's really up to the board, but I do feel strongly that people need to live there and be protected. I don't think we should live somewhere else and be protected. So,
Well,
would you propose adding language that says what?
the points in time that you just described.
So upon application and awarding and board decision, or?
Well, you said that primary residence was required at some time in the past as well, no?
Yeah.
Yeah, so I would imagine that should be incorporated in this one also. I mean, vague is not a good thing,
I
it's
know.
kind of thing. Obviously, yeah.
But then you get a challenge. I don't know. What does everybody else think?
You want to work on it?
You'll have your chance when we do the public hearing. Yeah.
I find 217 a little hard to read, and it would be helpful to me if the staff could just step back and kind of explain what the intention is.
So I thought I did that last time, but I can do it again.
Yeah.
I have the whole presentation. Right, so the first thing is that somebody can be registered, you know, if somebody decides to register somebody who has control of the building, so can certainly register people as protected occupants if they want to. And if the board issues an order, then that person is a protected occupant. How does the board make that determination? So here's the factors that we thought were important, that they use the unit as their primary residence, the person uses the unit as their primary residence, and we have some information here as to factors that could be considered to make that determination. And we can certainly add or subtract. They also had to have resided in the unit as their primary residence on the effective date of the law, and lack of consent of the responsible party does not affect the right of the person to protection under 7C. This is from the old 209B. That's not really a change, actually, right? So if somebody was there on the effective date of the law, using the unit as his or her primary residence on the effective date of the law, the owner can't say that they're not protected because they didn't consent. So that's D. And then E is, I'm sorry, for the people that came after the effective date of the law, if the owner consents to them being there and residing there, then they can be protected occupants, and here are some factors for the owner for the board to consider in making that finding. So, really, C is the biggest change, I think. So what we're looking for is people that, we're trying to capture
Also E.
people that are actually living there.
E is a big change.
No, actually, that's there now. That's in the section now. It's just reworded, but it's in the section now. Really.
Well, you've scrapped the privacy trumps all others.
Oh, yes. Well, that's kind of C. E captures the section about landlord consent. D and E talk about consent. C is really the one that changes before, at least in my mind, in terms of drafting. So, but yes, we have scrapped the primacy trumps all others language.
When I talk about that, I think actually the specific language of the rules. But I'm sorry.
Did that clarify for you, Ms. Delaney? I don't feel like I was very clear.
Well, you know, I mean, part of the, looking at 217, just as regards protected occupant versus eligibility for coverage of the unit. And I know we've kind of been headed in that direction since the 2010 amendment, in part because we felt we had the right to address protected occupant issues even during a period of time such as this when no new coverage applications can be submitted. But I have to give this some more thought with regard to my overall sense of how the board should be proceeding, determining what is a covered unit.
Well, this is not about a covered unit.
Right,
This is about who should be protected.
I understand this, but the whole notion of the primary residence test being part of determining protected occupant is still an issue I'm looking at and not comfortable with.
Okay, I mean, no, that's fine. So,
And particularly the week where I don't have to think about basements and windows and doors, I hope to have my thoughts clearer a week from now.
okay, I mean, we can certainly discuss it again a week from now, but if there are other comments that we could get on the table now for people to at least think about in the next week, I think that would be very helpful. So,
I have many more.
I'm sure you do, and I want to hear them.
So you're listing, in C, you're listing factors to determine primary residency. And we could talk about them, but why have you not just wholesale adopted the rent stabilization standard, which is a big body of law that, in other words, the courts have already, over the many years, determined what factors to use. There is a statute that includes tax return, vehicle registration, driver's license, other documents filed with the public agency, how many days you actually reside. Considering that the rent stabilization statute and the law have similar goals and they interplay all the time, it seems to be, why not just cross-reference stabilization factors?
Because I don't think it's the same thing, to be perfectly honest. The one thing, in the regular and stabilized world, you only have to be a primary resident after you sign a lease and move in. So that's certainly not true. You know, people are living there already in the loft world. So it's just a different animal. These factors are based on our cases, which the board has already said are some of the factors to consider. So that's why we chose to do that. If the board thinks we should go that way, I'm certainly not opposed to that.
Well, tax returns have appeared in our cases and it's not listed here.
But the issue, I don't think we've actually ruled on tax returns one way or the other.
For
It's
sure, is that
been-
the case that listed?
For sure,
I think that's the case.
that case has not gone through yet. That case has been voted on, has been tabled twice and voted on twice, right? For sure is 59 grand. isn't it?
But I think you do reference tax returns.
But the case hasn't gone through.
Well, we're talking about rules, and I guess the question is whether or not tax returns is a good idea.
If you want to add that as a factor,
I think
let's
that's,
discuss it.
But aren't we,
yeah,
under what you're discussing in rent stabilization,
yeah.
those are the grounds for an eviction receipt for someone who's not using a rent stabilized unit as his or her primary residence.
That's probably true, although the relevance of that I'm not sure.
Well, we have an existing rule that talks about grounds for eviction from an IMD, and I don't know that we've gotten to the redraft of that.
No, but we drafted it, but really just to put it in the language, we
Right.
really changed that.
So again, my position is that primary residence use should not be an issue in determining whether or not the unit is covered. Then when we split apart after 2010, the notion of the unit being covered versus who is the protected occupant, there was a desire to start to apply some kind of primary residence test to whether or not someone could be a protected occupant, which I'm opposed to. In my opinion, the proper order of things is to determine, and this was one of the first big court cases where actually it was a rather well-known artist whose unit was found to be covered, but there was the issue that it was not the artist's primary residence. The tenants challenged the grounds for eviction and lost, but that's grounds for eviction, not grounds for determining whether or not a unit is covered under the loft code. So it was kind of settled that a unit that might or might not be someone's primary residence still had to be registered. And registering the unit back in the day also automatically made that person the protected occupant. And then the primary residence issue was a ground for eviction. And as I've learned over the years, there are times where you have a tenant who has another address, whether it's a weekend home or registered at their parents' address for some tax or parking, auto insurance benefit, that even if you can successfully prove that the IMD unit is your primary residence, that becomes so expensive that in many instances people fold simply because they can't afford to make that fight. But now, in the last few years, we've seen the concept of primary residence work its way into coverage of protected occupant issues, where, in my opinion, it doesn't belong.
All right, but we're dealing with a draft rule that, if it goes forward, I think should be tightened up. And I think the courts have said that the rent stabilization law and the loft law should be read together. I think there's legislative history on this. I think that the city council was required to pass a resolution to stabilize the units covered by the loft law. So this kind of legislative affirmation for rent stabilization should at least it's some authority to at least consider some of the factors. And I suppose even if you don't accept that the factors should be exactly, and that we should adhere exactly, but certainly the factors should make the list. I mean, we're saying no one factor should control. That's fine, but where you say in a tax return you live, where your car is registered, where your license, I mean, all those things are factors. I'm not saying that the case is closed after one factor, but why not look at the stabilization code, look at those factors, and bring them into the list? Not as conclusive if you don't want to go that strongly, but at least have those factors. Although I think that we might even be compelled to follow stabilization on this issue. I think there are some court cases on this.
I'm okay with taking a look at the other factors and incorporating some of them and decide one way or the other. I would like to address Mrs. Zelini's comment, though, that I want to make it very clear, and I said it last time, and I will continue to say it, that primary residence is not a factor in determining coverage. The term primary residence does not appear in 281. It does appear in 284, and that's why 286. It does appear in 286. That's a distinction. I don't know exactly what date that case was, Mr. Delaney, but to me, 1992 is the applicable date here. Anything that happened before 1992 in terms of talking about primary residence, I mean, I think that the legislative enactment in 1992 was in reaction to cases that held that primary residence has no place under the loft law. So, again, only for protected occupancy. So I think it's a hard sell to say people should be entitled to this, what I think is really great protection, if they don't actually live there. So, but the board will decide.
Right, and our rules as currently written provide for that because failure to use a unit as a primary residence is a ground for eviction.
But the question is, if we know for a fact that the person isn't there, take Mr. Hughes, for example, why would we say, okay, you're a protected occupant, only to have the landlord then go to court and evict that person? Why should the board do that?
Well,
Maybe I'm missing
Hughes in the case we did decide today, is an issue where I need to look more closely.
I'm just using this as him as an example. We could use Ms. Mariner Smith because she's a similar example, and that's a case that's been decided already. She lived out in Mattatuck, right? South yeah.
Right, Mariner Smith is a set of facts that I found a little clearer than Mr. Hughes's. There's a lot to try to pin down.
Okay,
with
well,
Mr. Hughes.
let's talk about Mariner Smith, Ms. Hughes is a pending case we should talk about. So,
Right.
Yeah. So, in terms of Ms. Mariner Smith, she's not there. She's renting it, had been for years and years. Admitted that she didn't live there.
Divided it into units.
Yeah, so what's the rationale behind giving her protection?
In that instance, I couldn't find the rationale.
So this rule is basically trying to incorporate that line of cases, right? So saying if you're not there, you shouldn't be protected, but if you are there, you should. And whether or not you're the person that leased the unit, I don't know that matters that much under the law.
What does being there mean? Is it, in some cities, in some states, it's 6 months.
Right.
And there was this one incident where some respected woman went to California to teach for 2 years, and she was still protected occupant of that unit, even though she wanted, I don't know if she sublet it or didn't sublet it while she was going to. I don't think it would matter.
Is that Charles?
Yes, that's what she did.
She didn't sublet.
She didn't, all right.
She came home on vacations. That's Ms. Wells, right? Right.
Yeah. I mean, but
She had a teaching assignment.
she had a teaching or something.
Right. Right.
On
We
the other
had-
hand, Hughes only came there to feed us and look at his cats.
Right. So you had, Ms. Wells was off in Michigan teaching, but she didn't sublet. You had Mr. Yukai last month who was in the Peace Corps. I mean, so, people will be absent. They live lives, but it's still their home. I guess that's the question. And it's not, and I'm not saying it's an easy determination, but I think it's a determination that should be made because this is a tremendous benefit to people, and rightly so. But they should.
It's a sort of difficult thing. The former mayor of the city of New York has houses in 3 places around the country. I don't know whether he can spend 6 months
Around the world.
Around the world, yeah. Right until he was a legal resident of the city of New York, he was elected mayor twice.
Well, he's not applying for protected occupancy.
He didn't live in public housing.
No, actually, that's a good point, because the weighted temp days have long been settled by regs and the courts, which is why incorporating, I think, my stabilization standard would be a good thing. It would give clarity.
I sort of agree with that, but mostly I can't.
Right.
Basically because the whole situation about when one gets legalized, you become protected, is totally different than renting an apartment somewhere or living there for 40 years under rent stabilization. Just living there.
Well, why don't we take a look at the factors? Let's do this. Let's take a look at the factors of this, the other factors that are considered in the stabilized world. Let's throw them out there for discussion. And then ultimately, this is for a decision. This is just weird. We're proposing this. The decision is yours. And I'm not wedded to any of this. I can tell you what I feel strongly about and why. You can decide or not. These are your rules. So,
If, in the process of the next week, you come across some of the case law that Mr. Carter was referring to, and you move forward, I appreciate it.
Well, I can send you, Elaine, I have a few cases.
He referred
that
to-
talk about the relationship, the love club and the relationship.
okay.
Show you what I have, see how much weight you think it warrants.
Yeah, I'd be interested in looking at those.
Okay.
And if you, the city council determination that you mentioned
Yeah.
is one I've never heard of, or heard of and forgot, but
I have a copy of something. Let me send it around and see what you think of it.
true.
So Elaine, why don't I send it to you and then I'll leave it to you to share?
Yes, absolutely.
Okay.
That's not a problem.
Well, since, yes, but if you're ready to call it a day, you want me to consider it?
I think you should leave.
I think you should continue. At least till 4 o'clock. At least go to 4
Or if no one
o'clock.
wants to buy dinner, we can keep going after that.
Go ahead.
The chairman said yes. All right, so you're telling me C is the mechanism by which you spread the final C from the level. This is a good time to talk about that concept. So this is an enormous change that you're proposing. I appreciate that you're saying that it's our choice. I think that it is big. I think it's probably the biggest issue in the rules. I really think you should have given us alternate sections. I think putting this out there, just like that, I see it as biased, but I don't want to make that accusation. That's not fair for me to say. But I know that last time in the presentation you mentioned that staff thought it resulted in problems, but of course that was the first time we've ever heard of such problems. These cases appear every month virtually. I've been on the board 19 months. And I've never heard of a problem in all that time, case after case after case.
Other than for me.
Yes, of course, and that goes without saying. Absolutely. That's what I got from staff, because Elaine said staff has felt that they're a problem. And I feel that this scrapping of the concept is being driven by forces outside the law and outside the staff. We suddenly have large audiences showing up to these things. We have politicians showing up. But nonetheless, however we got here, we're here. And I'm going to address the merits of it. I'm not going to harp on this any longer. Yeah.
I just want to interject something there in that regard. And everybody obviously views their time differently. But every once in a while, I feel like the staff up here kind of takes a little bit of a hard shot that maybe they don't deserve. I can tell you that I have reached out to just about every member up there about clarification for things and thoughts that go through my head and all kinds of other stuff. And they have been absolutely phenomenal in getting back to me, offering to explain things to me, offering to speak, to take layman's language and translate to legalese and vice versa. So, I mean, maybe some of this feeling is simply that we're not reaching out like we have the ability to do. As they refer to it, they're here for us. But I'm quite sure they don't spend all day sitting there saying, well, like, what would Mr. Roach be thinking right now? How can I possibly think how I may help? I mean, they have things to do, so I'll leave it at that. But I mean, never, ever been denied open door policy to ask questions about things that aren't even necessarily on the immediate horizon. And I'm not saying that you were, I don't misunderstand that you, I just, sometimes I feel that, you know, communication is key.
I appreciate you saying that, and it was in no way meant to be a personal commentary whatsoever. In fact, Richard, you don't know that I've worked with both Elaine and Ronaldo at the ECB for many, many, many years. And our relationship is fantastic. And it's not meant to be a personal criticism whatsoever. I mean, that thought never even entered my mind. If it came across that way, that was not intended whatsoever. But nonetheless,
Yes, go for it. On the merits.
You did put out only one version of a hotly contested issue, and I think you should have put out both versions.
So do you want us to draft another version for next month?
I do.
Okay.
If it can be done that quickly, I don't know.
Next week.
It's not the right.
Next week?
No, I don't think.
Well, we could try. We'll try.
Yeah.
There's a lot more in what we have in chapter 2, so
Yeah.
if it takes more than a week
Yeah, to be perfectly honest, I think the rest of it is all downhill, so if we can hammer this one out, I think it would be so much easier. So I am certainly willing to put in effort between now and next week to try to get this
And if
as
it
soon
can't
as
happen,
possible.
if it can't happen next week, so be it. You know.
I don't know about the factors, because that's going to be more
Right,
research,
right,
but
right.
at least another draft.
Yeah.
Do you want to just elaborate a little bit about some of the repercussions that you're perceiving, and why this is a major fork in the road for the change?
Yes, I wanted to.
And then have the.
Yeah, I want to just briefly talk about the merits of the current concept and the downfalls of what's proposed, of scrapping. So currently we have a bright line rule, very easy to administer. Everyone's rights are clear. That's the difference between a rule and a standard. And in this kind of landlord-tenant concept, a bright line rule is very clear. The cases are easy to resolve. You don't get endless litigation. People know their rights, whatever they are. The lease is the lease. You get a primacy, that primacy trumps all of it. By enabling you to have more protected occupants in the presence of a prime lessee, you're creating the possibility of a prime lessee, creating an SRO, selling rooms to the highest bidder, because these are very valuable rights. If you get to be a protected occupant by being there, and I realize there are some other factors. You wind up in a situation where you can have more protected occupancy than the maximum occupancy under the law allows, right? The MDL and the zoning have a limit on the number of people in any particular dwelling. And you've got more protected occupants than the law allows. And there's no mechanism here to resolve those claims of having more occupants more protected occupants than the law allows you to do there.
I understand the argument that you're making, and that is actually an argument that was raised in Article 78, and the court held that the definition of family doesn't necessarily include relatives, so you could have lots of people who are living together and constitute a family, even if they are not blood relatives. So I do understand the point that you're making, where you have like one person in 4 borders, et cetera, et cetera. But the court actually apply a very expanded definition of family in that case, because you had lots of people who were not related to each other, but had lived together for a very long time.
But that might not be the only standard for mass occupancy.
Yeah.
I don't know, but it is a potential problem
Yes.
that you don't have when the primacy cuts off all over the shore.
It's not only primacy. I think I mentioned several years ago that there are buildings in this city where a landlord has rented out 6 or 7 different loft spaces to different people with one kitchen, one bathroom. I know personally of one instance where this has occurred. I mean, that's bringing up a completely different problem. You know, and the problem is that, you know, that somehow the city has to really make a concerted effort. I mentioned this to you before, make a concerted effort to try to get these illegal spaces in some kind of legal form. And we've stopped doing it, unfortunately. I mean, it's another issue. Sorry to bring it up, but the fact is that this happens.
The flip side to your concern, I guess, the notion that a prime tenant could create an SRO, and I'm not quite sure how they go about doing that under 217C. But one of the ways that loft units, IMD units, are distinctly different from stabilized units in a lot of cases, with the landlord's blessing, tenants did a lot of work in the unit, creating rooms, sanding floors, putting in plumbing, putting in kitchens. So if you have 2 people who agree to move into a space together, but only one signs the lease with the landlord, you can have someone who has a tremendous sweat equity investment, or sweat equity plus an investment in materials that went into constructing that unit. I think this is one of the areas where the concept of reading the rent stabilization law, the loft law, and pari materia doesn't work. And your hypothetical of an SRO, which conceivably kind of, or Elliot's, I think you've used the term longboat in the past. In these larger units, there are a lot of issues that we're going to have to sort out. But I am also focused on the 2 or 3 people who built an IMD unit with a lot of work, but only one person holds the lease. And I have, and from 1982 to 2010, those people submitted proofs of residency, they got covered.
I want to just flesh out some of your points, and I thank you for making them. As written, this would offer protection to people with no investment whatsoever, people who came later and never sanded the floor, and they really have no reasonable expectation to be protected. And yet,
Only if they're there with the consent of the landlord, right? I mean, the other people would had to have been there prior to the effective date of the law. Right, so we're talking about people that were there during the window period and were there on the effective date of the law.
You're reading C and D together.
Yes.
Yeah.
The people that came later, if the landlord consents to them being there, that's E, which we have now, actually, reworded a little differently, but E, then yes, they could be protected too. But not that they necessarily would be, but the landlord has to consent to them being there if they come later.
your standard for consent is not well done, I should tell you that.
Okay. Definitely open to suggestions on that.
Yeah, okay, and, well, I think what I meant to say, okay.
I'm sorry.
No, go ahead.
So is part of the idea that, I mean, if you have people who are living in an apartment, but they don't have a direct legal relationship with the landlord, yeah, part of these the landlord's consent is not really that requirement.
When did they get there?
I'm not looking at the timing, I'm trying to separate out the different factors so I can get a better grip on
Okay.
what the focus is. The focus seems to be moving away from the lease and focus more on
The actual occupancy.
On the actual
Yes,
occupancy.
that's correct.
Right, so therefore, whether if the people that are using it as prime residents, the tenants, whether they have, whether the landlord is having a direct relationship with them or not, whether they're lease or not, whether they're sublease or triple sublease or whatever, that's not part of the criteria. They're living there during the permanent time frame.
Right.
Which, that's part of what I think you're concerned
That's part
about.
of the problem.
Right, that's what I'm trying to flesh out.
And, also with respect to a friend, let's see, and someone else is there, if you didn't sign the lease, you don't have obligations, you don't have the same obligations that the lessee has. So the lessee is much more warranted for some protection than just a roommate. I mean, a roommate just doesn't have the kind of expectations that a lessee has. And the other thing is, in the world of landlords, in the world of real estate, ordinarily the statute of frauds, right? I'm not saying it's applicable, but as an analogy, in matters of real estate, you need a writing precisely because of people trying to make claims. And it seems to me that the prime lessee requirement is helpful in sorting out fraud, in making evidence clear, all the reasons why you have a statute of frauds. We could talk about E some more, we could talk about this some more, we could call it a day.
Is there any component of it that we can settle at this point?
I think this needs to be settled as a whole, frankly, and
Because they're
It's kind of a
connected.
concept.
And also, Elaine, just in terms of drafting, I know clarity is the goal. And I mean, the current law lacks clarity for sure, but clarity is everyone's goal. But as this is drafted with notwithstanding, the word notwithstanding appearing not only in this section also, but in another section referring back to this section, it's just not clear. And there aren't that many sensitive words here. This could be one section. I mean, it takes some effort, but to make things perfectly clear, you need it all in one somehow. And you can't have this notwithstanding and referring back.
So you'd rather consolidate it so that the moving parts are more interrelated?
Within the exactly, within subsections, exactly. This is really difficult.
So,
Because you were just
You're saying that E
C and
should-
D were being applied together as
Correct, it seems to be.
so therefore, does that make sense?
well, the different sections have it. Yeah,
Yeah,
okay.
and even the subletting section refers to, notwithstanding the last section, I said you gotta move the subletting into here too ultimately.
Oh, I really don't want to do that, because then you wind up with these really, really long rules, so.
Well, with proper headings and indentations, no?
You think so?
Conceptualization more than headings and indentations at this point.
Right, so
Yeah.
the two different issues, one is the substantive and the other is the presentation.
Yeah, there's a lot more work needs to, I'm sorry to say
No,
that.
I am more than willing to do the work. I mean,
Yeah.
that's,
And Ronaldo, when I complained last weekend, I said, all this effort. And you said, no, we're done. I'm like, no, you're not done. You're really not done.
Is it
I
worthwhile to have a substantive conversation rather than a presentation one at this point? Just to.
Yes,
Okay.
yes.
So maybe, I mean, I don't.
please.
But it seems to be that, so part of the idea is to try to move, the thought is to try to decrease the focus on the lease relationships and increase the focus on the actual, the tenancy. And so, and it sounds like part of your concern is that when we move away from the written documentation, the legal relationship between who the landlord is leasing to, you then are sort of, by its nature, that makes it more than kind of difficult to make decisions, evaluate people's rights. But I do think, I mean, as a general, I'm sorry, wasting time at around, but as a general thing, we're sort of moving farther away from kind of the real estate law and moving into more of the housing law. So we're moving more into the fact that, okay, people are living there, by definition, they've been living there, people have known that they've been living there, it's not like conspicuous, and therefore certain rights are, redeeming them to have certain rights based on that, which is not, I mean, it's...
Well, of course, this is granting an enormously valuable right.
Yes.
This is business.
Right.
And, another argument is the owners have certain expectations. I mean, if they traded buildings in the marketplace, while the current rule is in effect, you've got expectations, economic expectations, and you know that the law in terms of financial matters respects economic expectations, and you don't make a change this big without a really good reason.
But we're presuming that, I mean, in the first place, with all due respect to the real estate, the property owners, that they're attempting to, trade on the economic value of the property that is currently not in legal conformance, by definition, right?
That's okay, because
No,
we have Article 17.
It's not okay. It's not okay because it's not, because until it gets through the Loft law program, it's not, we're essentially, I mean, I think, maybe I'm looking at it wrong, but essentially, we have an illegal use that is, that in effect, the state is saying we're granting a stay on enforcement.
Right.
The fact that this is illegal until, as long as you go through this process. But there's a risk factor about, you can't say, well, therefore, we can say what the outcome is. And so, I mean, I don't think, maybe.
So in essence, what you're saying is there should be an expectation upon the owner who may be trying to sell
Right.
the property or something, that there's going to be issues, because he's trying to deal with a property that is not completely legal.
Right. It is like saying, it's trying to sell a property with an imperfect title or with, with some other legal dispute which is outstanding. And there's got to be discounted accordingly, unless you're just prescribing to the greater fool theory.
No, but of course, there is reliance on an
No, I understand. Yeah, no, I mean, I agree. I'm just saying, it's not like, there's a risk factor. I'm not saying that means it's worthless. But there is a risk, and therefore, as long as we're sort of acknowledging. And then, I mean, the presumption is we're talking about people who are living in the building. Right.
True.
So therefore, I mean, we're not talking about like some kind of, residual right that, as you're saying, fraud, that like people are going to be coming out of the woodwork.
Well, it's someone who happens to be there without a lease, could have been there recently, with little ties to it. I mean,
Right, but presumably they've got to prove, and maybe this is, this needs to be harder, more rigorous, let us say, that they need to prove that they were actually living in the building during the period in order to be deemed eligible.
yeah, sure.
And it's not, that's the thing, I mean, there's still going to be people filing claims, owners answering, cases going to oath, and factual determinations. So it's not that,
Well, that our current rule, that cutoff does reduce a lot of problems. There's no doubt about it. I mean, we see that in our own cases every day. If we can get rid of them in the paragraph. When I say get rid of them, I mean the issue.
yeah.
So just quickly, in E,
Yeah.
the proposed E, 1, 2, 3, 4, so these factors. Accepted rent from the occupant. I mean, is this one time? Is it on a continual basis? I'm going to think about it. I'm saying answers now. Number 2, contact the occupant for access. Oh boy. I mean, the owner has a leak, and the knocks on the door, he needs to get in there. Someone answers the door, you're now you're a protected occupant.
Well, I think the idea is that they knew someone was living there. That's the thing. Because if you know someone is living there and they're not supposed to be there, and they're not really covered, then why aren't you getting rid of them? So I think that's where those kinds of things come from.
But
So
is that the public policy that you want pursued? That you want the owners to start emptying out the buildings? I mean,
no.
you want them to start
That's
sending
not what-
letters
no,
that say, I
that's not
don't
what I'm
consent to
saying.
your occupancy?
No.
Okay.
No, I think that that idea came from a case in which the tenant, the owner reached out. In one case, the owner actually filed an access application against the person. So that's hard to say you consent when you're filing clearly with the Loft board because they want access to do legalization. And there was another case in which the owner actually called the person and said, I need access. So the owner knew the person was there, had actually had conversation with the phone number, all of the personal information about the person, and then the owner in a case said, why didn't you say?
All right, I mean, that's more than little 2 says.
Right, that's where the idea and the concept is.
Yeah, and then number 3, listed a document on filings. Well, that's nice, but what does that mean? That needs to be fleshed out. Of course, any other fact, of course, is relevant. This is going to breed litigation.
The number 3, I think we were envisioning the narrative statement.
Right.
You serve a narrative statement on someone, and then obviously you're inviting them to be aware of what's happening in their
Are they
environment.
obligated?
Yes.
So they're obligated, that's automatically, you consent to their occupancy, you're obligated to send them the statement?
Well, right now, I understand is that the owner sends them to whoever they know is in the space. I mean, they'll send it to the person that they know. All occupants. That's what the rule says. So you can't say, we didn't know Martha Cruz was living there when you send it in the mail to Martha Cruz.
So in other words, it's proof that the owner
Was aware.
It's just so, he
Well,
acknowledges
it's
the
a
standard?
factor to consider.
Just acknowledges the standard?
Well,
I guess you're saying it is.
it's more than knowledge. I mean, if the owner knew that the person's there, this narrative statement was filed 10 years ago, and you've known that the person's been living there for 10 years, you can't hardly say that you didn't consent when you've taken no action to evict the person.
What if you
You've
send a
taken no
letter?
action to do
What
anything.
if they send a letter today? I hereby do not consent to your occupancy. Will that totally undercut this?
This is coverage. This is coverage. The narrative statement is the building's already covered.
Oh, okay.
The narrative statement, if the tenant's getting a narrative statement, the building's already covered. It's most likely the unit's already covered, and the occupants are already covered.
Right.
So it's not the same.
Yeah.
You shouldn't be.
All right. It's getting late. I just wanted to give my thoughts, and maybe if you wouldn't mind me starting up next time just to maybe summarize my thoughts on this one.
You summarizing your thoughts and me summarizing? Oh, yeah, fine. Yeah, that's fine.
Okay. Next time, if
Yeah.
you're ready to start. Okay, yeah, thank you very much.
Okay.
If it's okay with everyone else.
This is next week, right?
Yeah.
Next week.
2 o'clock. 2 o'clock.
2 o'clock next week.
2 o'clock right here.
Right. about to say that.
What floor we on, third?
You're right here, third floor, you're right here. I really want to say thank you for your diligence. I know everyone's spent quite a bit of time, invested quite a bit of time, not just the staff, but the board members, into the rulemaking. Certainly it's very important to us to get this going. But before I conclude this meeting, as you know, we have 2 public member vacancies now on the board. I just want to ask you if you happen to know anyone who you believe is credible, suitable, and for these time-sacrificing positions, do not hesitate to let us know so we can forward this information to the mayor's office. As you know, they're responsible for appointing persons to the board, but I want to give board members an opportunity to make recommendations. Certainly, you don't have to pass them to us. You can do it directly to the mayor's office of appointments, but certainly we can do that for you. This concludes our October 19, 2017 Loft Board meeting. Our next public meeting will be held at 280 Broadway right here in the 3rd floor next week, October 26, 2017 at 2 p.m. Thank you, board members. Please sign in and hand me your attendance sheets.